Hi, and welcome everybody to the WashU Roundtable discussion of some recent high-profile Supreme Court cases. What we're going to do today is we're going to have some of our talented faculty kind of take us through some of the recent cases, the rationales, how those cases interact with the precedent, some of the jurisprudential moves that are made, and how those cases might be applied to other areas. So we're going to talk about 5 cases today: Biden versus Nebraska, 303 Creative LLC, Students for Fair Admissions, and Moore versus Harper. We've gotten some questions in advance, primarily about WashU's reaction to the affirmative action decision. So once we're finished talking about the cases, Russell has been thinking about that case in some detail, and he'll have some words to say about that. At the close, after we've talked about each and every case, we're going to take questions. And the way we're going to take questions is you just throw it into the chat, and then I'll read it to our particular panelists. So I'm looking forward to hearing from my colleagues who know many, many things about these issues. And so we're going to start with Professor Ron Levin talking about Biden versus Nebraska.
Okay, well, good afternoon, everybody. I'm going to be talking about Biden against Nebraska, which is a case in which the Supreme Court held that President Biden's student loan forgiveness plan was unlawful. That plan would have canceled $10,000 in debts for borrowers with incomes below $125,000, and lower income students could have gotten up to $20,000 forgiven. So overall, about 20 million Americans would have had their debts canceled entirely. The Department of Education adopted this plan on the basis of the so-called HEROES Act. And that statute allows the Secretary of Education to waive or modify any statutory or regulatory provision applicable to student loan programs, as may be necessary to ensure that the borrowers are not in a worse position financially because of a national emergency. In this instance, the claim was that the loan forgiveness was necessary because of dislocations caused by the COVID pandemic, which Presidents Trump and Biden had indeed declared to be a national emergency. Well, the attorneys general in 6 red states, including Missouri, brought suit to challenge the plan and claimed that the secretary had exceeded his authority. And that suit was eventually successful in the Supreme Court with a 6-3 vote. Chief Justice Roberts writing for the conservative majority, and Justice Kagan dissenting on behalf of herself and the court's other 2 liberals, Justices Sotomayor and Jackson. Now, a threshold issue in this case was whether the states had standing to bring it at all. It wasn't easy to see how there could be a case or controversy here, because this was a program that basically bestowed benefits on borrowers, so it didn't seem to hurt anybody. In the interest of time, I won't discuss how the Supreme Court nevertheless managed to find that Missouri had standing, but suffice it to say that its reasoning was a stretch, indicating that the court was eager to reach the merits and strike down the program. So let's talk about the merits. The crux of the issue was whether the loan forgiveness program could be described as an exercise of the statutory power to waive or modify existing loan conditions. And the dissent by Justice Kagan said, well, the Biden plan fits squarely within those terms. But Chief Justice Roberts said, no, modify implies moderate revision. And the word doesn't really describe a massive program that completely rewrites the framework that governs millions of loans. And similarly, he said, waiver sounds more like identifying a specific legal requirement and waiving it, not creating an entirely new program. And more generally, he pointed out that this program was a huge departure from any previous use of the modifier waive power. But Kagan's answer to that was, well, the pandemic itself was much more widespread and disabling than the earlier situations in which the statute had been used. So naturally, the government's response should be proportionate to that hardship. In the end, I think the statutory language arguments were inconclusive, and the case turned on the respective regulatory philosophies of the justices. So we would naturally expect that liberals would be more likely to say the pandemic called for bold action, and the executive branch should be able to alleviate hardships by using all powers that were at least arguably within the scope of the Secretary's authority. But you also would expect that the regulation skeptics would be mistrustful of big government and not inclined to support unilateral executive action on the basis of this statute, which was at best an awkward fit with the nature of the loan forgiveness program. Well, sure enough, you had the 6-3 split vote, which is exactly what you would expect from this court and what commentators did expect. But there's another aspect of the case that gives the opinion broader significance, which is that Roberts rested on the major questions doctrine. This is a doctrine that the court formally adopted last year in West Virginia against EPA. And that doctrine is not completely well defined, but basically it seems to say that an agency needs to have clear congressional authorization before it may adopt any policy that would have vast economic and political consequences. In the West Virginia case, the court used it to strike down EPA's Clean Power Plan, which had been a cornerstone of President Obama's climate change program. The court also relied on the doctrine, without calling it by that name, earlier in the year to invalidate two of the Biden administration's other COVID-related measures, the CDC's eviction moratorium and OSHA's vaccination program for large employers. Now, in the student loan case, nobody disputed that the economic consequences of the forgiveness program would be major within the meaning of the West Virginia case. But the major questions doctrine itself has been heavily criticized. One reason why the doctrine is controversial is that it seems to say that the executive branch should be powerless to address new problems, even emergencies like climate change or a pandemic, without getting a specific green light from Congress. And the court has claimed in this line of cases that it's only carrying out what Congress itself would presumably want. I think, though, the court's been engaging in a kind of projection here. The court's conservatives seem to assume that they themselves would not choose to authorize an agency to adopt this kind of policy on its own initiative. So Congress probably didn't do so either. But the problem with that reasoning is that there have been many cases in the past in which the court has read ambiguous language in regulatory statutes more generously. And in fact, some of those enabling statutes were enacted by Congresses that were more liberal than the current Congress and these justices are. Another of the court's rationales is a big separation of powers argument that any major policy decision should be made by the legislature and not the executive. And that line of argument has appeal in the abstract. But these days, in an era of legislative gridlock and ideological polarization, partisanship, and general lack of cooperation on Capitol Hill, the argument seems to ring somewhat hollow, because in practice it will often mean that neither agencies nor the legislature will be able to act. And the way Justice Kagan said in her dissent, the major questions doctrine is profoundly undemocratic, because when the executive branch adopts a major rule, it is accountable to the electorate for doing so. But when the unelected judiciary imposes a doctrine that prevents that choice, there is no political recourse. In sum, I think the major questions doctrine remains controversial, it remains in flux, and we should all keep an eye on it as it develops in the coming months and years. Thank you.
Thank you, Ron. Super interesting. We are now going to turn to Professor Magarian to talk about 303 Creative LLC. Greg?
All right. Well, hi, everybody. Thank you for spending part of your afternoon with us. So 303 Creative versus Elenis is probably one of the most important First Amendment free speech decisions to come down in many years. Here are the basic facts of the case. A woman named Lori Smith in Colorado is a website designer, does business as 303 Creative. She said that she wanted to expand her business to include providing websites for weddings. Smith is a conservative Christian who rejects the validity of same-sex marriage. And Colorado has a public accommodations non-discrimination law that includes sexual orientation discrimination, so prohibits discrimination in the provision of goods and services on grounds of race, sex, and other characteristics, including sexual orientation. So Smith feared that if she expanded her business to produce websites for weddings, Colorado would enforce its law to make her provide services for same-sex couples. She therefore went to court and sought a judicial ruling that the First Amendment protected her right to discriminate against same-sex couples. The Supreme Court eventually, by the same 6-3 split that you just heard about from Professor Levin, the conservative-liberal split, ruled that the First Amendment's free speech clause bars states from requiring anyone to provide expressive services that are contrary to their conscientious beliefs. Let me give you a little bit of doctrinal context for what the court based this holding on. There is a longstanding First Amendment principle that prohibits the government from compelling people to speak against their beliefs. So the most famous case of this sort is West Virginia Board of Education versus Barnett, a World War II era case that protected Jehovah's Witness children against a rule that said they had to salute and recite the Pledge of Allegiance. The court in that case said that's a violation of the freedom of conscience, a violation of the freedom of speech by forcing those kids to speak words that they did not believe. There's also a line of cases that provide some protection for the right of free association, in particular, the right not to associate with people you don't want to associate with. And that line of cases is important because one such case, Boy Scouts of America versus Dale from about 2000, specifically allows, interposes that right of expressive association against claim of sexual orientation discrimination. There's a case that's sort of at the nexus of those two principles from 1995 called Hurley versus Irish American Gay Lesbian Bisexual Association. In that case, the court held that the Boston St. Patrick's Day parade, the organizers of that parade were protected by the First Amendment against having to include a float by an Irish American Gay Lesbian Bisexual pride group. So the court cited those past cases and principles in issuing this holding in favor of Smith and 303 Creative. But the thing that made this case different and very important because of its difference is that this is the first time that the court has invoked the First Amendment to protect a business in providing services for being able to discriminate based on sexual orientation or any other basis. I want to talk a little bit about the sort of legal significance of this case, but first, as with Professor Levin's account of the student loan case, a word about standing. This is something that a lot of people have wondered about. How was it that Smith was able to get this case before the Supreme Court to begin with? It's not unusual for the court to decide important First Amendment cases with speech interests at stake before a law is enforced. So that aspect of the case isn't so unusual. What's a little bit unusual is that ordinary principles of standing require that a plaintiff has to show evidence of a concrete particularized injury, that there's actually something bad that's going to happen to them if the law they're challenging gets enforced. And the record in this case, Smith's showing that she wanted to provide websites for weddings was not terribly strong evidence. And what that suggests is that the court really wanted to decide this case. Okay, so the media have generally talked about 303 Creative as a case about religious liberty versus LGBTQ rights, and it is that, but it's broader than that. It's really a case about free speech versus non-discrimination laws generally. The key factor that the court pointed to in this case was that the services Smith was providing were expressive in nature, creating a website. Now, there are all kinds of public accommodations that clearly are not expressive. Restaurants and hotels are not going to come within the scope of the First Amendment. But we're at a law school today, so let me talk about two examples of other kinds of expressive services: legal services and educational services. Legal services are quintessentially expressive. Lawyers speak on behalf of their clients, and lawyers often send strong messages by their decisions about which clients to represent. I believe that under the principle of 303 Creative, if a law firm or a lawyer announced that they were strong believers in white supremacism, the First Amendment would protect that law firm or lawyer from a non-discrimination law that required them to provide services without regard to race. Educational services are also quintessentially expressive. Everything that we do as educators involves speech. So I believe, again, under the principle of 303 Creative, that if Washington University decided tomorrow, or another university decided tomorrow, that adherence to religious dogma, for example, was inconsistent with the institution's view of a liberal education, I believe 303 Creative would protect the university and allow it to deny admission to members of religious communities based on the idea that the university could choose how to distribute its expressive services in that way. Just to close with a little bit of a focus on race in particular, because going forward, my colleagues are going to talk about a couple of cases that are very directly focused on race, the big affirmative action case and the big voting rights case. And I think it's important to view 303 Creative within the scope of those race cases as well, as we think about the overall effects of the court's decisions this term.
Thank you so much, Greg. That was quite interesting. Now we're going to turn over to Professor Katz and Kim to talk about Students for Fair Admissions. Andrea, do you want to go first?
All right, let's go. So it seems like quite a lot of people in the room are already familiar with Students for Fair Admissions versus Harvard. So I'm not going to spend too much time on the details. This is the case that came out this June that's already been described as effectively ending affirmative action in higher education. For instance, Larry Summers, the former president of Harvard, was understandably less than pleased with the holding. He called it a radical decision upsetting longstanding practices whose likely result will be the degradation of an American university system that is the envy of the world. I will let people higher up and more qualified than myself talk about Larry Summers' gloomy prediction. But in about 6 minutes, I want to tee up two questions about the case. Number one, is Students for Fair Admissions a radical departure from our previous case law on the question? And two, is its idea of equality, specifically racial equality under the Constitution, correct in your view or incorrect? All right, the textual hook of this case is the famous phrase equal protection in the 14th Amendment. As you all know, the 14th Amendment was passed after the Civil War by a Congress that had realized that just because the Civil War was over didn't mean that all vestiges of slavery and racism in America had been eradicated. So in very famous language, the 14th Amendment issues a warning to any state that would try to deprive people of their rights as citizens. Quote, no state shall deny to any person within its jurisdictions the equal protection of the laws. All right, there is the rub of this case. Equal protection of the laws. What does this actually mean? In the early years of the 14th Amendment, the court takes this language and it blinks. Under the shameful regime of Jim Crow, the court allowed that states could segregate Black and white Americans in society and treat them differently when it came to rights to property, labor rights, voting, and of course, education. So long as both white and Black Americans were living under this segregated regime, this counted as equality. Some saw this system as wrong even at the time. It's the famous Plessy versus Ferguson case of 1896. That upholds Louisiana's segregated Black and white railroad cars. And it's in this case that the great Justice John Marshall Harlan dissents, writing, ours is a colorblind constitution. So what does it mean to be colorblind? This is the question that was decided this year. Jim Crow, of course, also meant segregated schools. So by 1954, which is the year that the famous Brown versus Board of Education comes down, you have about 20 US states with laws on the book segregating their public schools by race, despite the language of the 14th Amendment. The landmark Brown famously holds that this is wrong. Separate but equal is inherently unconstitutional under the Equal Protection Clause, and the right to a public education, quote, must be made available to all on equal terms. All right. The big problem of Brown, which gets us to today, is this. Just because courts said schools had to be integrated doesn't mean that, poof, they're suddenly integrated, right? Unsurprisingly, in the mid-20th century, white families didn't usually choose to send their children to the old Black schools. And also Black families often lived far away from white public school districts in de facto, if not de jure segregated neighborhoods. Another problem of Brown, what does it mean for a school to be integrated under the law, right? Does it mean actual equal attendance by races proportional to the larger population? Or does it mean that schools' doors are just open potentially to all applicants? So these are tough problems. Among the solutions that pop up are to move students across districts. This, to the limited extent it was applied, still didn't erase wealth gaps or gaps in educational achievement. So another solution that pops up among institutions of higher learning and societal mobility, like this one, is of course affirmative action, or admissions programs that give a preference to students of particular races that had historically experienced discrimination. The first case that ever takes up the constitutionality of these programs is the 1978 Bakke, which considered UC Davis Medical School's program of setting aside some seats for Black applicants. The med school argued that its program was justified for 4 reasons. 1, to reduce a historic deficit of disfavored minorities in med schools. 2, to remedy the longstanding effects of societal discrimination. 3, to increase the presence of doctors in underserved communities. And 4, to obtain the educational benefits that flowed from a racially diverse student body. In Bakke, a deeply splintered court upheld only the 4th, educational diversity, as a compelling reason for which a school could treat students differently on the basis of race. And for complex reasons, it's this opinion in Bakke that becomes the law of the land. In 2003, the famous case Grutter upholds Bakke, reiterating that if schools are going to treat students, are going to consider students' race in admissions, it could only be for the purposes of achieving the educational benefits of diversity, and that when they do so, race can only be considered as one factor among many. So this brings us to today. The lower courts take up North Carolina and Harvard's admissions policy in response to challenge by this nonprofit group, Students for Fair Admissions, and they both uphold the policies from challenge. The Supreme Court, in the same 6-3 split that we saw in Ron's discussion and Greg's, reverses them and strikes these policies down by a vote of 6-3. The holding in the case is that these 2 admissions programs violate the Constitution's Equal Protection Clause because they treat students on the basis of race. Now, of course, the universities defended these programs as necessary to ensure upward mobility for student minority groups, but this is besides the point, according to the court. Chief Justice John Roberts writes that the 14th Amendment's core purpose was doing away with all governmentally imposed discrimination based on race. Race-based admissions programs, however well-intentioned and implemented in good faith, had to be subjected to the strictest of scrutiny, and these programs failed the test. I'll just conclude by bringing back this point of a colorblind constitution, okay? The term colorblind comes up 56 times in the opinion based on my command effing, and it's at the heart of the controversy. Does equal protection of the law mean no racial classifications, period? Or does it mean no unfriendly racial classifications, but benign ones are okay? I will stop there.
Thank you, Andrea. That was awesome. And now we're going to turn it over to Professor Kim, who, in addition to being an employment scholar, happens to also be my neighbor. So excited to have Pauline talk.
Great. Thank you so much. I'm going to follow up Professor Katz's excellent summary of the SFFA cases and their context to discuss a related issue that has been receiving a lot of attention recently. And that is what exactly are the implications of the case for employment? So since the decision was issued at the end of June, there's been a lot of discussion about whether anything has changed for employers. And in particular, does it mean that diversity, equity, and inclusion, so-called DEI programs, are under legal threat? So I think there are 2 ways to answer that question. One is legal and one is practical. From a legal perspective, nothing has changed. SFFA doesn't apply to employment because, as Professor Katz said, that case involved a challenge under the Equal Protection Clause. Private firms are not covered by the Equal Protection Clause. They are prohibited from engaging in discrimination by Title VII of the Civil Rights Act. So the relevant precedent under that statute has been pretty stable for years. Employers are prohibited from discriminating on the basis of race and other protected characteristics. Voluntary affirmative action programs that involve racial quotas are forbidden except under some very narrow circumstances. At the same time, under Title VII, employers are not only permitted, but they are even encouraged to take steps to change their practices when those practices have the effect of excluding disadvantaged groups from the workplace. So the EEOC has issued guidance stating that employers should take steps to correct the effects of past discrimination and to prevent present and future discrimination. In a statement that was issued right after the affirmative action decision, the EEOC chair confirmed that under Title VII, DEI programs that, quote, seek to ensure workers of all backgrounds are afforded equal opportunity remain legal. So the SFFA case entails no change in the relevant legal doctrine when it comes to employment, but the decision could have a practical impact. The Supreme Court's decision has emboldened critics of DEI programs and led them to claim that such programs violate the law. So, for example, earlier this month, there were 13 Republican state attorneys general who sent a letter to Fortune 100 companies, warning them that their DEI programs might be illegal discrimination and that they would hold them legally responsible. So again, nothing has actually changed legally. If a company was engaged in racial discrimination in hiring before June of this year, it was unlawful then and it could have been legally challenged. If, for example, a white worker thought he had been discriminated against because of a corporate DEI program, he could have filed a legal claim. And there have been a handful of such cases. They've generally not succeeded. Now, one of the difficulties in talking about affirmative action and DEI programs is that people are not always talking about the same thing. For some people, affirmative action means that a Black person is getting an opportunity, a job, or a place at a university because of their race, and there is someone else who deserves it more. And so from this point of view, affirmative action amounts to a form of discrimination against white applicants who have suffered harm. But the term affirmative action can also refer to any positive effort that is made to remove unfair or arbitrary practices and to improve racial equity. Initiatives of this kind are also described as DEI efforts. And these initiatives do not involve treating any individual less favorably because of their race. So, for example, an employer might decide to expand its recruitment efforts beyond a handful of elite universities to include a broader range of universities that are less elite, including recruiting from graduates among historically Black colleges and universities. Or an employer might decide that rather than relying on word of mouth to recruit new workers, it's going to advertise its job openings broadly, including in media that will reach groups that are underrepresented in its workforce. An employer might decide to publish in advance the criteria for promotion to certain positions rather than just relying on managers' gut feeling and discretion in deciding who should be promoted. An employer might decide to crack down on racially and sexually derogatory speech in order to ensure that its workplace is welcoming to all. So all of these changes and practices can be characterized as DEI efforts. Each of them will make the workplace fairer. Each has the potential to improve racial equity as well. None of them entail discrimination of any type against white workers or men, and no one can legitimately claim that they have been harmed by initiatives of this type. So, are there companies out there that are going too far in their DEI efforts and maybe making race-based hiring decisions that violate Title VII? I suppose that's possible, but I doubt that it's very common. For one thing, employers have very strong incentives to hire the best candidates for a job, regardless of race. And many of the DEI initiatives that were announced with great fanfare a few years ago have actually not produced really significant gains in workforce diversity, which is what you might expect if the companies were actually imposing a rigid racial quota. So the unfortunate thing in my view is that the critics of DEI programs are promoting the idea that these programs are zero-sum, that anything that benefits members of disadvantaged racial groups must be harming white workers. But that's not necessarily the case. When employers change their procedures to make them more fair and open and transparent, all workers can benefit from that. So my concern is that the heated rhetoric around DEI in the wake of the SFFA case may cause some companies to back off on their commitments to improving workplace equity for everybody, not because those efforts are unlawful, but because they are afraid that they might be sued anyway.
Thank you, Pauline. Super interesting. Now we have Professor Crum talking about both Moore versus Harper and Allen versus Mulligan. Travis?
Thanks, Scott. I'm actually only going to be talking about Allen versus Milligan today. So I'm going to share screen here. So you'll have to bear with my PowerPoint a little bit. But I'm putting it up so that you can see some maps that I'm going to have to show you in a moment. And I have the honor of talking about the one case that was not a 6-3 conservative liberal decision, but rather a 5-4 decision in which the liberals were joined by Chief Justice Roberts and in most of the opinion by Justice Kavanaugh to affirm longstanding precedent concerning the VRA. So a little bit of doctrinal background before we dive into the dispute at hand. The Supreme Court has interpreted the Equal Protection Clause in two diametrically opposed ways when it comes to redistricting, and in such a way that even the court itself admits it imposes haphazard claims of liability, or to put it more colloquially, it's a Goldilocks problem. You have to consider race to some extent in the redistricting process, but you can't consider it too much. So let's unpack these two doctrines. Beginning in a case called White versus Register from 1973, the court endorsed a doctrine called racial vote dilution. And under this doctrine, if a redistricting plan packs or cracks minority voters, or in more sophisticated legal terminology, denies them an equal opportunity to elect their candidates of choice, and the mapmaker did so intentionally, then you violate the Equal Protection Clause. This accords with the kind of anti-subordination approach to equal protection from the Warren and early Burger Court eras. And in 1982, Congress agreed and codified this approach in Section 2 of the VRA. And when it did so, it got rid of the intent requirement and said that as long as a plaintiff can show discriminatory effects, that's sufficient to establish liability. Now, after Section 2 was amended in 1982, the Supreme Court decided a case called Thornburg versus Jingles in 1986, where it imposed a series of preconditions that plaintiffs needed to establish to bring a Section 2 claim. And those basically boil down to a showing that there's residential segregation. In other words, you can create a 50% plus one majority minority district in a compact geographic area. And the second and third requirements boil down to essentially a showing that voting is racially polarized. So that's the Jingles vote dilution line of cases. On the other side of the ledger, we have what's called the Shaw line of cases. These are a more colorblind, anti-classificationist approach to voting rights, and these emerged in the 1990s. And under the Shaw line of cases, if race predominates during the redistricting process, then the district needs to survive strict scrutiny. And as Professor Katz told us earlier, strict scrutiny is a very difficult standard to meet, and statistical studies have shown that the overwhelming majority of policies that are subject to the strict scrutiny fail. So we've got a colorblind Shaw line of cases on one hand, and we've got a more anti-subordination, race-conscious approach, Jingles line of cases on the other. So this brings us to Alabama, and this is where I'm going to start using the slides here. So what I put up here is on the left-hand side is Alabama's post-2020 redistricting plan. And it has 7 congressional districts, and it is, according to the 2020 census, Alabama is 27% African-American. But despite this fact, there is only one congressional district that is majority Black, and that is this district here, Congressional District 7, that includes part of what is called the Black Belt, and it's called the Black Belt because of the fertile soil that exists within the region, but because of, in the antebellum days, that's where plantations were based, that is where a large percentage of Alabama's Black population still lives today. And so District 7 is centered around the western end of the Black Belt, captures some of the Montgomery suburbs, captures a large Black pocket of population up here in Birmingham. And that's the only majority Black district in Alabama. So plaintiffs brought suit in Alabama, saying that we are entitled to a second majority Black district. And as part of that showing, they needed to show demonstrative plans where they could draw that second majority Black district. And that's exactly what plaintiffs did. So here are 4 examples of majority Black districts that the plaintiffs expert put together. You still have Congressional District 7 here that is majority Black. That's because it's expanded into Birmingham ever so slightly. And then Congressional District 2 is majority Black. And this is capturing a large portion of this population here along the middle part of the state, and also reaching down into the city of Mobile, which is a port city with a large maritime-based economy and a military base. And so the plaintiff said, look, we've done exactly what you told us to do on your jingles. Here are the demonstrative plans. Alabama responds by saying, whoa, whoa, whoa. Anytime you consider race in the redistricting process, that triggers Shaw. And the appropriate way to approach this line drawing process for these demonstrative maps is to use an algorithm blinded to race and see if it can create a 2 majority Black districts without telling it to do that, and see how often that occurs. And it also raised the specter that Section 2 of the Voting Rights Act might be unconstitutional as applied to congressional redistricting. So very bold arguments coming from Alabama. Now, the 3-judge district court, which was 3 Republican appointed judges, looked at the facts, looked at the law, and said, this is a pretty straightforward situation where Alabama has likely violated Section 2. We're going to issue a preliminary injunction against these plans. So, surprising decision. Goes up to the Supreme Court on the so-called shadow docket, and the Supreme Court on the shadow docket rules 5-4 with the Chief Justice in the dissent, saying that we're not going to let this preliminary injunction go into effect, and therefore the enacted plans were in place for the 2022 election. Similar dynamics played out in challenges to Georgia and Louisiana's congressional districts. So this might have changed some of the results in the 2022 election. So then we get up to the Supreme Court on the merits docket. And here we have a very surprising decision in which Chief Justice Roberts writes for the court and affirms. He distinguishes between Shaw and the Jingles line of cases by saying, look, Section 2 does not require racial predominance. Section 2 merely requires racial awareness. And Shaw only penalizes states when you cross the line from mere awareness to predominance. He also writes what I would characterize as a paean to statutory stare decisis. He says that Thornburg versus Jingles has been the law of the land for decades now. Congress has had opportunities to revise it. It hasn't done so. And it rejects Alabama's constitutional avoidance arguments based upon the 15th Amendment and Congress's enforcement authority under that. So one way to reconcile SFFA and Milligan is to say SFFA is about the Equal Protection Clause and judicial supremacy, what the court thinks about equal protection, and Milligan is about a much more narrowly targeted 15th Amendment and Congress's authority under it. Now, this doesn't mean that the VRA is out of the woods. I mentioned at the top that Justice Kavanaugh did not join the entirety of the majority opinion, and he wrote a separate concurrence basically saying that Alabama had not raised what he termed a temporal argument, that the VRA might be outdated, that Congress might have been able to take these types of steps in the 1960s, 1970s, 1980s, but today we live in a different world. And so he teed up this challenge. And a lot of the themes that Justice Kavanaugh mentioned there are now being litigated in lower courts, specifically in Louisiana. So I think that that temporal challenge is going to come up to the court. And you have 4 justices who join Justice Thomas's dissent, who are very much interested in limiting the VRA. The last thing I'll say, because it's been in the news recently, is what comes next in Alabama. So the preliminary injunction decision by the lower court said that any remedial plan, and I'm quoting here, will need to include 2 districts in which Black voters either comprise a voting age majority or something quite close. So the Alabama General Assembly and governor enacted a new plan earlier this week, and this is what it looks like. And Congressional District 7, still majority Black. It went from 57% African-American to around 50.5% African-American. But if you notice, Congressional District 2 looks very different than the plaintiff's plans here. And that's because Alabama was unwilling to break up the city of Mobile and the Gulf Coast part of the state. And so this congressional district is only 40% African American. And the plaintiffs' briefs are due on Friday to the 3-judge district court, but I don't think it's going to surprise anyone to say that they are going to challenge this, to say that this is not close to meeting the standard from the 3-judge district court. And we're seeing basically a setup for maybe another trip to the Supreme Court in this case. So thanks, everyone. Looking forward to your questions and our discussion.
Thanks. Thanks so much, Travis. Fascinating. So now we're going to turn over to Russell, who has been thinking about the affirmative action decision in light of WashU, and many of you had sent questions beforehand, wondering what Russell was thinking about, and so he's going to tell us.
All right. Well, thank you, Scott. I thank all my colleagues for their informative discussion of the cases. So the law school obviously has an admissions program. And one of the advantages of when the decision came is, of course, the admissions year was essentially over. So we are thinking about the shape of our future admissions plans and programs. And we're doing this in conjunction with talking with the University Council. Now, the first thing I'd say is we have not finished our consideration of the issues. And so we are reading the opinion carefully. We're also reading what others are writing about the opinion carefully. And every day there's an article or two, by the way, on both sides, criticizing the opinion and supporting the opinion. So we're trying to stay on top of that. So now I'm going to move into what we think we see in terms of the future. So first of all, the law school's admissions process prizes very predominantly academic performance in the past and the promise of academic performance in the future. That is not going to change. That's how we have a good law school. You want good students in a very good law school. So with that, I will now say what we are aiming to do is fully comply with the Supreme Court's decision. Now, what does that mean? Well, the first thing the court said, and it said it a number of times, is that race cannot be a factor in the admissions process with respect to deciding yes or no. Now, there's a little bit of a qualification, though, by the court in its decision, which some people think is a big qualification. Others read it very narrowly. The court goes on in the Chief Justice's opinion to say that a school may consider how race might have contributed to a strength in an applicant's file that you otherwise consider in your admissions process. So an example would be, does the law school look at whether people have promise of leadership? That is a common thing, I'll be honest, in law school admissions processes. So what the Supreme Court says in the Chief Justice's opinion is that the law school may take into account that it was an individual's race that produced the example of leadership that you may consider in admitting that person to the law school. So in the past, we have articulated a number of things besides stellar academic performance that we take into account, and leadership is one of them. Grit and determination is another. Work experience is another common one. We also look for rural students. We look for urban students. So we have a long list. So race can be indirectly considered to the extent it produces qualification for one of the criteria that you otherwise apply, and that you have to apply and make available to all people to help them gain admission to the law school. third thing that I'm pretty clear about, although there's some discussion to the contrary in some of the commentators, is I believe the decision squarely applies to the provision of scholarships and financial aid. I don't think you could say race could be considered directly. And indeed, the government has been out for years policing racially exclusive scholarships, and we have none that we ourselves fund and provide. On the other hand, we think, and the vast majority of people who comment believe, that race can, in the sense of figuring out who are you going to reach out to for your applicant pool. So for instance, I had a student last year who was an evangelical Christian, a very outspoken one. Why did he come to WashU? Well, he came to WashU because our evangelical student organization, aided by our admissions office, sends out flyers to evangelical universities. That was how he came here. We also reach out to HBCUs. We also reach out to all schools in Missouri because Missouri provides a large number of our students. So we think pool enhancing programs and ideas may continue, but to go back to the first point I made, the Supreme Court has made it clear that Grutter versus Bollinger is overruled to the extent that it allows race to be directly considered in deciding about admission, and in my opinion, in deciding about scholarships and financial aid. Now, I'm just going to end with a personal note. I was born in Southern Ohio in a town that was segregated. The year after I was born, and 75 years ago today, Harry Truman desegregated the armed forces of the United States. My father, who was a really conservative man, thought it was the greatest day that he saw in his time as an active duty officer. He went to West Point. So I believe the United States has a continuing duty, particularly to African American people, to do things to ensure that African Americans have a real participation in all aspects of American life. And that's all I'll say.
Thank you, Russell. So now we're going to open it up to questions. We had some in advance that I can go with, but if anybody has a question, if you can just type it in the chat and then I'll pose it to the professors. I know absolutely nothing about the Constitution, so I will not be answering anything or even trying. So I guess I'll start before I don't see anything in the chat. So here we go. This is from Jonathan, and he's asking Ron about Biden versus Nebraska, whether I wonder if Biden's argument would imply that any potential illegal action the administration could take, which does not directly harm anyone, can never be challenged in court because no one will ever have standing. Is that correct? Or supposing Biden had won the standing issue, would some other entity, Congress, potentially have had standing to sue against the loan forgiveness program? I think what Jonathan is asking is, how would you get standing here if Missouri didn't have it?
Well, I skipped over that, but in fact, Missouri got it. And I'll just explain how. Missouri has set up a corporation, a public corporation, which services student loan borrowers, and they receive fees for doing that. There's a group called MOHELA. And the argument that Missouri made was, look, MOHELA is going to be injured if the Biden plan goes into effect because there'll be fewer loans out there. MOHELA will get fewer fees. Well, I think that was clearly so, that MOHELA would be injured by the Biden plan because of their role. What was tricky in the case was that Mohila and Missouri are not the same. Yes, Missouri chartered it. Yes, Missouri appoints its officers, but it does not receive revenues that Mohila earns. It is not responsible for Mohila's debts. It is a separate entity. It can sue and be sued on its own. And Mohila did not endorse or participate in this lawsuit at all. If they had sued, they would clearly have had standing. But the question was, how can Missouri claim standing on the basis of it? Well, Roberts says, oh, because they're a public instrumentality, and therefore Mohila's losses can be deemed to be Missouri's losses. Just as in an earlier case, we found that a state university's losses could be attributed to the state in which it exists. This was a factually contested point, whether there was any real harm to Missouri going on here, and that's why I said it was a tricky move. A lot of people thought the court could not rationally justify finding that Missouri was being injured, but a lot of those same people thought, nevertheless, the court's going to say that because standing is manipulable. It's often used in a result-oriented way, and it wouldn't be the first time by any means that the court found standing on a very thin showing of injury because they were trying to find a way to get to the merits.
All right, thank you, Ron. So we're going to ask again from things that have been sent in.
Actually,
oh, go ahead,
Scott. There is a question in the chat. And I'm ready to answer it. Scott,
go ahead, Russell.
Okay, so this is from Nimrod. So most colleges and universities have, for I would say 30 years, declined to accept scholarships that were racially exclusive, and frequently they have gone back to donors, if the donors are alive, and said we need to make this not racially exclusive. They have more recently done that with scholarships that were limited to one gender, so women only or men only. So most of those, in fact, all of them at WashU are gone. They don't exist. The question that I'm not sure what the correct answer yet is, that still exists, is there are organizations that provide scholarships, mainly, I will tell you, to African Americans that are not the university itself or the college, and they will award the scholarship to that African American man or woman, and then they will hand it to the university to give to that student or to credit to his account. So one issue that we're looking at is that permissible under this decision? I do not believe, as I said, we can run a racially exclusive scholarship, but the question is, can we accept a scholarship and apply it to a student's account, which may be, and most of them are for African Americans, and they come from African American self-help organizations. But they're awarded directly to the student. We don't make a decision about the awarding. The organization makes that decision. So I think part of the answer, Nimrod, is that we're thinking about it, but we ourselves do not administer any such scholarships and haven't for years.
All right, I have a question for Greg. How do you think the opinion could impact the provision of services such as religiously run homeless shelters? Does the opinion extend, in your view, to those sorts of situations?
So I don't think it does. There was a decision a couple of years ago that I had not brushed up on, so I'm going to be a little sketchy on this, but allowing for religious preferences and religious discrimination in the provision of social services, but that was based on a different legal issue and a different legal analysis. This case is all about the First Amendment freedom of expression. And so I alluded to this briefly in mentioning hotels and restaurants. I think the same thing would apply in the case of something like a homeless shelter. I believe that if you are providing, if any entity is providing services that are not themselves expressive, that do not constitute expression, and I don't think giving someone a bed in the homeless shelter is communicative or expressive any more than giving someone a table at a restaurant is. If the service isn't expressive, then the 303 creative First Amendment ruling should not bear on that. But there may be other statutory constitutional considerations that do.
Thank you, Greg. Now we have a question from a prior student of both Greg and Pauline's, and they ask, given the 6-3 splits, what are the practical options to expand the court? That's one thing. And are we at a point where privacy rights established through the case law and implied rights generally will no longer be protected? And so I think we'll give that to Pauline, maybe on the second point. I don't know if you want to talk about the expand the court thing, Pauline.
So the expand the court issue, I wish our colleague Dan Epps were here, because he's written an enormous amount about this. So I don't know that I have any particular insight. I think that there are obviously a lot of proposals that are being floated by people who disagree with what the current majority is doing. I think that it is worth thinking about this, but it's also important to be very cautious because we're talking about an institution, not just for this moment, but constructing an institution that is durable over time and with very many potential swings in different directions, right? And so, I guess I haven't studied it deeply enough to have a particular proposal other than to say that I think we need to be cautious in terms of really tinkering with the deep structure of the institution. That said, I think sort of certainly things like making ethics on the Supreme Court more transparent. I think that's actually a relatively small step that would help increase confidence and trust in the court, and is something that that is important. But ultimately, I don't think we can escape the fact that the court is a political institution, and that has a lot of implications. On the one hand, it is to some extent, to the extent that it's going to be cabined in how far it goes, it's going to be a matter of how the political institutions are interacting with it and how the public as a whole interacts with it. And I think that's, sort of one of the areas where people who might be frustrated with the court should actually be sort of thinking about how the court interacts with the political system as a whole.
Thanks, Pauline. Now we have a question for Andrea, Professor Katz. How could universities continue to try and correct prior practices of discrimination and exclusion in the wake of this affirmative action decision?
You're
Andrea, I
muted.
think you're muted.
Gosh, you'd think that after all this time on Zoom, I'd know that by now. I'd say two things about this. Correcting previous practices of discrimination, right? So it's Bakke already, 1978, that says schools aren't supposed to be doing this. Schools aren't supposed to be using race to correct historical injustices, right? This is what the UC Davis Medical School tried to argue. This is why we're doing it. And the court said, no, you can only use race to achieve the educational benefits of diversity. Now, my personal view is that Bakke is a massive misstep and put schools in a bind. So now they're not talking about correcting legacies of discrimination. They're talking about the educational benefits of diversity, this mantra we hear a lot about. And Chief Justice Roberts in SFFA points out rightly that diversity is kind of standardless. This is the term he uses, right? So that's one thing I'd say. The other point is more about means. The majority says basically racialism can't be used to correct racism. You can correct racism by other means, economic programs or civil rights laws that bar actual instances of discrimination. You cannot correct racism by programs that look at groups' historical legacies and seek to give them a leg up.
Great, thank you. I think we have time for one more for Travis, and this is about Justice Kavanaugh's concurrence in Mulligan. This audience member was wondering if you could expand upon what he concurred on and why he may not have joined the majority opinion.
So I think it might take a little while to figure out why Kavanaugh didn't concur in all of the Milligan opinion, but the portion that he didn't concur with dealt with some of these questions about the line drawing difficulty between racial awareness and racial predominance. And his concurrence, I think, is, especially reading it after SFFA came out, some of the themes from the Kavanaugh concurrence in Milligan you see in the affirmative action case itself. That one of the problems, according to the court, for affirmative action programs in higher ed was that they had no endpoint. That UNC and Harvard repeatedly doubled down on the idea that we're not going to get rid of these anytime soon. And Kavanaugh took the famous line, or maybe now infamous line, from Grutter that the court expected these programs to be gone in 25 years and kind of really ran with it. And so I think that aspect of Kavanaugh's thinking of there is some sort of time limit on how long these types of race-conscious remedial measures can be in existence is going to form the sort of crux of the next challenge to Section 2 of the VRA. And in some ways that echoes the rationale of the court in Shelby County. The Shelby County court said the current burdens of a statute need to be justified by current needs on the ground. And you're seeing very, related strands of doctrine kind of coming together in Kavanaugh's concurrence to say Section 2's time might be up. And he appears to be the swing vote on this particular question moving forward.
All right, I want to thank everyone. We are at time, and I wanted to thank Professor Kim, Levin, Crum, Katz, and Magarian, and Dean Osgood for all of their work. There were a couple of questions left. I'm certain that if you email the professors directly, they will engage with you. And I wanted to thank everybody who came out today, and I hope to see you all at our next event.